Hello, my name's Sarah Hayes. I'm a solicitor in the Employment Department at Paris Smith. Over the course of this podcast, we're going to be talking about settlement agreements. This podcast will answer some of the frequently asked questions raised by employees. We will also talk about some practical guidance on what you can do if you're presented with a settlement agreement. So, a good place to start is to look at what actually is a settlement agreement. A settlement agreement is a legally binding document whereby a current or former employee agrees to waive or settle all their possible employment claims against their employer. This is commonly done in return for a payment, which is usually made shortly after the termination of employment. The purpose of the agreement is to record the full settlement terms. It will include written details of any financial payments which are being made and a list of the various claims that are being waived. The agreement will also set out some other important details governing the arrangement. It is highly likely that the settlement agreement will include a confidentiality clause. This means that you should be careful not to discuss the terms or existence of the agreement with anyone else, and your solicitor will be able to advise you on this further. So why do employers use settlement agreements? A settlement agreement can provide a clean break to both the employee and the employer. It can offer a quick alternative to the time and cost associated with a redundancy process or formal disciplinary route. The benefit to your employer is that the employee is waiving all of their employment law claims and the terms of the settlement will be confidential. And what is the benefit to you? Well, the terms that are negotiated through settlement agreements can often represent a better financial outcome from that which an employee may achieve through issuing a case at an employment tribunal. This is partially due to the uncertainty and litigation risk of issuing a claim at a tribunal. However, it can also provide the employee with control over specific terms, such as a reference or an agreed announcement. These are terms that can be extremely valuable to an employee and which we advise on a frequent basis. How long will it take to agree the terms of the settlement agreement? Generally speaking, settlement agreements can be concluded relatively quickly. If you are happy with the terms of the proposed agreement, your solicitor should be able to finalise the agreement within a few days, and in some cases it can be concluded on the same day. Of course, if there are further negotiations needed, then that will mean that the process takes longer, and your solicitor will be able to advise you on this. The timeframe is usually dependent on how quickly your employer responds. If you do have a particularly short or specific deadline, your solicitor will do their best to accommodate this. It will be really helpful if you let them know the timescales at the start of your meeting so that they are fully aware of this. So let's have a look at some practical steps you should follow and why you actually need to see a solicitor before entering into a settlement agreement. As a starting point, if you are issued with a settlement agreement, you should always read through it very carefully. A settlement agreement can only become legally binding once you have taken independent legal advice on the terms. This means that you are required to take a copy of the agreement to an employment law solicitor. Your employer may be able to put you in touch with a solicitor, or you may be free to choose one. You will then attend a meeting with the solicitor. This can be conducted face-to-face or via a telephone call, and this will typically last between 1 to 2 hours, depending on the circumstances and any questions that you may have. The purpose of this meeting is for the solicitor to advise you on the terms of the proposed agreement. The solicitor will also advise you on its effect on your rights to pursue any employment claims before an employment tribunal. As part of the agreement, the solicitor will be required to sign a certificate to confirm that they have given the requisite advice to you. To ensure that you get the most out of your meeting, it will be helpful if you bring along a copy of your contract of employment. Alongside the financial clauses of the settlement agreement, there are other important provisions set out. Your solicitor will explain what each clause means and can answer any specific questions that you may have. The agreement is likely to include a legal fee contribution towards the cost of your legal fees. The value of this contribution varies, but it is commonly around £250 plus VAT. Sometimes it can be higher depending on the background. If you wish to negotiate on the financial sums that you have been offered or the terms of the agreement, you may exceed the legal fee contribution offered by your employer. Your solicitor can discuss this with you and will be able to provide you with a cost estimate if necessary. So, do you have to sign the settlement agreement? Well, the short answer is no. Settlement agreements are completely voluntary and their terms must be agreed voluntarily by both parties. Once the agreement has been signed by you and your employer, it will become legally binding. It is therefore really important that you are not forced into signing it if you're not completely comfortable with the terms. Of course, if you decide that you do not want to sign the settlement agreement, your employer will not pay you the compensation sum. So how do you know if you're getting a fair deal? This is a commonly asked question. The legal role of your solicitor is to explain the terms and effects of the settlement agreement itself. However, your solicitor will be happy to advise you on the merits of any potential legal claims you may have against your employer. This will involve considering if you could have an unfair dismissal claim or any discrimination protection. This will help you to establish whether you are being offered a fair settlement package. If you would like to negotiate on the financial package that you have been offered, your solicitor will be able to discuss this route with you. Usually, the decision to negotiate involves weighing up the employment right claims you are waiving against the benefits of any compensation you are receiving. You may also wish to negotiate on the specific wording of certain clauses, and this is something that your solicitor will be experienced in advising you on. When will the compensation be paid? Usually, settlement sums are paid within 7 to 28 days of you signing the agreement or in the next available payroll. However, this can vary depending on your termination date or what has been agreed. The payment terms are usually contained in the settlement agreement, and if you have any questions, your solicitor will be able to confirm this to you. Thank you for listening, and I hope that has been a useful introduction into some of the commonly asked questions you may have about settlement agreements. Paris Smith has an 8-strong team of qualified employment law solicitors, and we advise individuals on settlement agreements on a regular basis. We are equipped to guide you through this process, and if you would like to speak to a member of our team, please do not hesitate to contact us. All of my contact details can be found on our website, and once again, my name is Sarah Hayes. Thank you very much for listening.